I'm Gloria Browne-Marshall. Welcome to Law of the Land. I am here to give you a front row seat to the legal action. This year, the U.S. Supreme Court will rule on issues as diverse as campaign finance and abortion, affirmative action, prayer, and poisoning a false friend. Their decisions could further a conservative agenda limiting civil rights protections for African Americans and other people of color. There are two cases on the docket involving allegations of racial injustice. Mccutcheon versus Coalition to Defend Affirmative Action, a Michigan referendum amends its constitution to prohibit race and sex-based discrimination or preferential treatment in public university admissions. This may be just another way to end affirmative action in the state of Michigan. It was only a short time ago that the civil rights community was devastated when the Supreme Court ruled in Fisher versus University of Texas that, if possible, the university must replace the use of race, even as a single factor in admissions. One day after that Fisher decision, the Supreme Court ruled that the pre-clearance provision of the 1965 Voting Rights Act, which protected against discriminatory voting laws, was unconstitutional. Over the past 20 years, the U.S. Supreme Court has restricted protections against race discrimination in education, voting, and employment. This current Michigan case may allow the court to give states a mechanism to end affirmative action or any civil rights laws by public referendum altogether. In a public referendum like that in Michigan, most minority groups would be outnumbered because it is a statewide vote. In Mount Holly, New Jersey, African American residents challenged that city's redevelopment plans by bringing a case under the 1970 Fair Housing Act. Mount Holly, New Jersey, called their homes blighted and sought to replace the black community's low and moderate income homes with new housing, which they could not afford. Historically, when urban renewal policies have led to a destruction of African American homes, it's been challenged. Under the Takings Clause of the Fifth Amendment, the government may take private property by eminent domain, but only if there is no proven racial bias. Although the black community did not prove discriminatory intent, the Mount Holly versus Mount Holly Gardens citizens case will determine if a disparate impact or unfair impact lawsuit can be brought under the Fair Housing Act, 1964 Civil Rights Act, and 1965 Voting Rights Act. The Fair Housing Act was passed during the Civil Rights Movement. Nationwide, complaints about racial discrimination in housing remain high, second only to employment discrimination, according to the EEOC. There are two abortion cases on the court's docket. In Oklahoma, a law prohibiting the use of drugs to induce abortions is challenged in the case of Klein versus Oklahoma Coalition for Reproductive Justice. While in Massachusetts, a law establishing a buffer zone or distance by which protesters must stay away from abortion clinics is challenged in the case of Mccutcheon versus Coakley. Protesters argue the buffer zone violates their free speech rights because it keeps them too far from the intended targets of their protests. A prayer case in Greece, New York, involves whether city meetings can open with a religious prayer. All denominations are allowed to present a prayer. However, the First Amendment prohibits government from establishing or endorsing any religion. But "In God We Trust" is on American currency. "One Nation Under God" is recited in the Pledge of Allegiance. The U.S. Senate even has a chaplain named this year Barry C. Black, an African American who is a Seventh-day Adventist. The Greece, New York versus Galloway case raises many concerns about whether religion may have any role, directly or indirectly, in state, local, and federal government. Politics and money are before the court in Mccutcheon versus the Federal Election Commission, or the FEC. Sean Mccutcheon is a wealthy Alabama businessman who wants to contribute more than the legal limit to Republicans' candidates. Mccutcheon challenged the FEC limit of $74,600 every 2 years to political parties and $48,600 to political candidates. Mr. Mccutcheon believes limits on contributions diminish his expression of enthusiasm for a particular candidate, thus diminishing his freedom of expression or free speech. However, Solicitor General Donald B. Verrilli, Jr., representing the U.S. government, argued financial contributions without limits will lead to a corrosive appearance of corruption. He said also it creates a sense of indebtedness on the part of politicians. In 2010, the Supreme Court ruled 5-4 in the much-debated Citizens United case that corporations have a First Amendment right to free speech in politics, leading to billions of dollars being spent in the 2012 presidential election. However, Supreme Court Justice Antonin Scalia, a conservative, said he saw nothing wrong with big money in politics. This Supreme Court will also decide whether a Pennsylvania wife who poisoned her backstabbing best friend committed an international crime. Carol Bond tried to kill her best friend upon discovering the woman was in an affair with Mrs. Bond's husband and had given birth to his child. Because she used a highly toxic poison, Bond was prosecuted for violating a chemical weapons treaty. She argues her case belonged in state criminal court, not prosecuted under an international chemical weapons treaty in federal court. The real question here is less about Mrs. Bond and more about the power of Congress to determine when and how a treaty should be applied. The U.S. Supreme Court begins each term in October and ends in June. 9 justices will hear about 200 appeals chosen from thousands of civil and criminal cases tried in America's state and federal courts. With power equal to the President and Congress, their decisions create the laws of this country. I'm Gloria Browne-Marshall, and this is Law of the Land. Thank you for watching. See you next time.